Constitutional law expert Shadrack Gutto says Public Protector Busisiwe Mkhwebane's latest report on President Cyril Ramaphosa should be welcomed as the Constitution requires transparency, accountability and openness. This follows Mkhwebane's announcement yesterday that she found Ramaphosa had deliberately misled Parliament about the 2017 Bosasa donation. The 500,000 Rand campaign donation was made to Ramaphosa's son Andile by the CEO of services company Bosasa, Gavin Watson. Last November, Ramaphosa told Parliament that the money was obtained illegally for the services his son provided, but he later said the payment was a donation towards his campaign. Mkhwebane says she has referred money laundering allegations to the NPA to conduct investigations on the matter. In a statement, the presidency has described Mkhwebane's findings as unfortunate, saying the public protector has failed to properly consider his submissions regarding the donation.
It's a very important case, and I'm glad that the president is really going to court to try and challenge it on the basis of the powers of the public protector. To start with, I think we have to start by understanding what the public protector's office is required by the Constitution to do, or the public protector, and that is to be able to investigate and any conduct of state affairs and public administration in any sphere of government, and it is if something is alleged or aligned to be improper. So in this case, is it proper or improper for politicians and political parties in canvassing for elections really to receive money from anywhere? If that was the case, then it would lead to total destruction of good governance, of open and credible and accountable democracy. And I think all those are provisions within the Constitution. In this particular case, at the point that what the president really in this case is being required to be able to, take a proper project action is that the money was used or was donated to him. He's going around to be able to justify it and say it was sent to his trust bank account and so on, and he didn't know. And the fact that he has admitted that now he knows afterwards that the money was donated to his campaign, I think raises a lot of questions which need to be really clarified, I hope, by the highest court in the country, the Constitutional Court. But we also have to read it in other contexts, the Public Protector Act. We have to look at the constitutional provisions are expanded by areas such as funding of political parties. The state pays money, or government pays money, or the taxpayers' money to political parties, given their proportional representation in Parliament. At the time, the president was deputy president of the country, deputy president of the ruling party. And the question is, when they get donations, we don't know where they're coming from. It can come from billionaires elsewhere. It can come from governments anywhere in the world. And we will have a very weak state and not credible and lose people's confidence or the citizens' confidence in our electoral system and the way it is governed and who really pays the piper in that case, because these people are just donating, they must have an interest. So I think it is a very useful matter that ought to go forward, but we can't make a judgment. I'm not judging whether the president is right or the public prosecutor is. That ought to be, and the matter, the public protector is only accountable to the National Assembly. And I think that is important. The matter, the report should go to the National Assembly. Once it has to be dealt with, and the indication